matter to come before us this morning is State of Ohio versus Ted Warren. Full sides 115 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time for rebuttal, I'm keeping your clock this morning and keep you apprised of the passage of time. The court's ready to brief and we're ready to proceed with the argument.
Good morning, Your Honors. My name is Brent English. I am counsel for Ted Warren. I would like to reserve 3 minutes of my time for rebuttal. Your Honors, this case involves a commercial truck driver whose name is Ted Warren, who was involved in a motor vehicle accident on August 23rd, 2014, while driving a private vehicle, basically an old pickup truck that had four-wheel drive, but the four-wheel drive was not engaged. On August 23rd, 2014, at approximately 11:44 in the evening, he was proceeding up a road called West Liberty here in Worcester, and was proceeding to turn onto a road that comes in at an angle called Oak Hill. Oak Hill, for Mr. Warren, as he was coming up West Liberty, he was coming up at an elevated angle, and then he would turn onto Oak Hill and go up a sharp turn, not a sharp turn, excuse me, a sharp hill on Oak Hill, as he was on his way home. At that time, as Mr. Warren proceeded toward the intersection, he was going, as he testified, 20 to 25 miles an hour. There is no conflicting evidence in the record with respect to that. And as he made the turn, a motor vehicle accident occurred involving another vehicle that had come down Oak Hill, the sharp turn, and had come down and had stopped at, not a sharp turn, sharp hill, and had stopped at the bottom of the intersection. In this case, the driver of the other vehicle, Mr. Miller, testified. His wife, who has a different last name, whose name was Beachy, also testified, and a police officer from the city of Worcester named Kaskowski also testified. Mr. Kaskowski, the officer, never saw any aspect of the accident, and of course he was not therefore competent to testify as to anything that may have happened. The owner of the other vehicle testified that he saw lights coming and a vehicle was going to make a turn. There's no dispute that Mr. Warren had his turn signal on, and as he made the turn, a collision happened. He wasn't sure why the collision happened, he wasn't sure how the collision happened, and there's no evidence in the record as to where his vehicle was in relation to the right lane that Mr. Warren would be following. Mr. Warren was charged with a violation of Section 331.34 of the Codified Ordinances of the City of Worcester, and that has 3 subparts, as the court is aware of from the briefs. There was no specific subpart that was cited. The citation, however, did claim that his violation was a, quote, failure to control. Since there was no specific section of the subsection of the section that was cited, that he was cited under, was specified on the citation itself, there was a request for a bill of particulars that was filed by myself on behalf of Mr. Warren, so that we could find which subsection of the law Mr. Warren was actually charged with, so we could defend the case appropriately. The prosecutor in Worcester decided that it wasn't necessary to respond to the bill of particulars other than to say, look at the citation, which we did. So we're a little bit of a circular argument here, but in any event, the case proceeded to trial based upon those facts. At the close of the state's case, where Mr. Miller simply testified that a collision had occurred and did not know any of the particulars, and the police officer testified that a collision had occurred and did not know any of the particulars, and Ms. Beachy had said she wasn't paying attention and didn't know any of the particulars, Mr. Warren moved to dismiss this charge on pursuant to Criminal Law 29 on the basis that, construing the evidence most favorably to him, none of the subsections by which he could have been charged was in fact proven beyond a reasonable doubt. Well, that's what the citation calls a failure to control 331.34. And I understand exactly where you're coming from, Your Honor. I'm sure you're going to say that subsection A says, no person shall operate a vehicle without exercising reasonable control over the vehicle. three separate potential offenses within Section 334. And so one of the arguments that we made in the trial court, one of the arguments advanced in our brief in this case, is that it's a violation of my client's due process right to not to know specifically what section of the law he's charged with violating so that he can defend himself. We raised this issue with the trial court, and the trial judge said, well, he could be charged under any of the three sections. My point precisely. And he wasn't. And so I argued on the Rule 29 motion that there is insufficient evidence on each one of these sections in order for him to have been, to be convicted. The court overruled the motion. Then Mr. Warren himself testified. And Mr. Warren testified that he was driving up the road. He was paying full attention to what he was doing. As he turned, somehow the vehicle slid, and it slid into Mr. Miller's vehicle. He did not know where Mr. Miller's vehicle specifically was on the road. He surmised that it was the result of a rainstorm that had just happened, and there was a lot of gravel that had been washed down into the intersection. So as he made the turn in the most safe and reasonable, appropriate way, not speeding in any way, not doing, as he called it, a Dale Earnhardt up the road. This guy's a commercial truck driver, and he called himself an old Marine. Just as he was reasonably turning, that the vehicle somehow slid. He wasn't sure why it slid. And he also testified that his brakes were real soft at the point when he put his brake on as he was turning and wasn't sure why. The question that's raised in this question ultimately is whether or not the evidence is sufficient to conclude beyond a reasonable doubt that this is a failure of reasonable control. And our argument is this.
Counsel, before you get to your
Yes, sure.
argument, I have a question about facts that your client testified to. He testified to gravel having been washed out due to a heavy rain.
Correct.
Did he testify as to how he concluded that that was the fact? I understand that this happened late at night. Did he say that he was able to see that as he was making the turn?
No, not at all. He did not know that this condition existed.
How did he have learned it? I guess
Because he was on the side of the road and was looking at the road itself and saw that there's a bunch of gravel down at the bottom of the road, which was not visible to him at all. These were completely paved roads. It would not be reasonable to expect that. And it had rained. So his surmise is that the combination of the gravel at the bottom, not his speed, not his failure to pay attention, not his reasonableness in driving, combined with the wet road, resulting would cause his bullet to pick up to strike Mr. Miller's vehicle. So,
and there was testimony of an injury to him, maybe in the facial area, that he had some bleeding, etc. Do you know whether the truck that he was driving had airbags and whether airbags were full?
it did not have airbags. It's an older model truck. It did not have airbags, and no airbags were involved.
Okay.
So he hit his head on the windshield, causing a laceration in the front wheel.
Okay. And finally, was there any discussion in cross-examination, or we will find it in the record, as to whether or not anyone testified that the injuries that he sustained were consistent with his traveling at 25 miles an hour? Consistent or inconsistent?
There is no testimony with respect to that subject at all.
Thank you.
So the legal question, to come back to where I was and dovetailing with Your Honor's question, is whether or not this ordinance is a strict liability offense or whether this is something else. And I think pretty clearly by looking at it, this is not a strict liability offense. If you have a motor vehicle accident, that doesn't necessarily mean you're at fault in a criminal context. The statute says if you fail to exercise reasonable and ordinary control over the vehicle, then you're guilty of violating this offense. Now, this is not Mr. Warren's burden. This is the state of Ohio's burden. So the state of Ohio had to show that Mr. Warren failed to exercise reasonable and ordinary control over his vehicle. All of the evidence in the record shows that in fact he did. But I'm anticipating the argument from the prosecutor, which is, well, if he was exercising reasonable and ordinary control, then he would not have had an accident. Well, that's, I suppose, a simplistic way of looking at it, except for the question of what the real issue is whether or not a reasonably prudent person with similar circumstances would have been driving in the manner that Mr. Warren was driving. And there is no question that a reasonably prudent person under these circumstances would have done so. No reasonable person could have seen the circumstances that existed, and that ultimately led to Mr. Warren having this accident. So I would respectfully submit that the trial court got it wrong and failed to grant the motion for a directed verdict or a motion for judgment of acquittal, both initially as well as after Mr. Warren testified. The other argument that we make in the case is that the judgment is against the manifest weight of the evidence. And if you look at the evidence as a whole, which you must do as the so-called 13th juror, even though there's no jury in this case, if you look at exactly what the facts are, you can see that there is an accident. There's no question about that. But that no one who was able to testify with any credibility at all, that no one contradicted Mr. Warren's testimony, that he was driving reasonably, that he was not speeding, that he was doing everything that the law required of him, and that he encountered a situation that he could not have otherwise anticipated, and an accident happened. This is a civil matter. And Mr. Warren is liable civilly, okay, so be it, but that doesn't rise to the question of whether proof beyond a reasonable doubt was shown in this case. And when the judge announced her decision in the case, she said, well, there must have been something that he was doing that caused this accident. Respectfully, that's not the standard. That's not it at all. And although we didn't have an opportunity at that point to object further to the court's reasoning, if you look at the record and you see what the court's reasoning was, I think you will see that, in fact, this is not proof beyond a reasonable doubt.
And also we just want to make minutes.
All right, and I'm just about done, Your Honor. And therefore, I would ask you to reverse. All is there. Thank you.
Good morning, Your Honor. May it please the court, Andrew Ruler for the Athlete State of Ohio. The appellant has raised a few issues here. I think the overall issue in this case is truly whether a uniform traffic citation must designate a specific subsection under which the defendant is charged in order to put them on notice so that they could prepare their defense. And this all goes to the sufficiency of the evidence arguments that the appellant has raised under his allegations that the trial court erred when it failed to grant the requested criminal rule 29 motions. In the city of Barbershire versus O'Connor, the Supreme Court of Ohio has already addressed the issue of whether a uniform traffic citation must designate the specific subsection under which the defendant is charged. And the Supreme Court of Ohio held that the traffic citation properly charges the defendant with an offense when it describes the nature of the offense and makes reference to the ordinance that gives rise to the offense. Here, the uniform traffic citation, which is available at the record at 007-008, charged the defendant with failure to control. And that was in violation. It also included 331.34 of the Worcester Codified Ordinance. Thus, the citation was proper, adequately apprised the defendant of the offense for which she was charged and referred him to that specific section. When we look at that Ordinance 331.34, we see that the title, Failure to Control, corresponds to Section A, and that is, no person shall operate a vehicle without exercising reasonable and ordinary control over such vehicle. The title then, semicolon, and its weaving, that corresponds with Section B, that you should not operate a vehicle in a leading or zigzag course. And then C, full time and attention, corresponds to C, that you shall not operate a vehicle without giving your full-time attention to the operation of the vehicle. From the arguments raised at trial and the evidence presented at trial, as well as the appellant's brief, it's clear that we are under 331.34A in this instance. And given that the Supreme Court of Ohio has said, you just need to notify them of the offense and general nature of it, referring to the ordinance section or statute, the citation was proper. Additionally, in further support of the citation was proper, later was the 8th District Court of Appeals, the City of Cleveland versus Austin. They held that the uniform traffic citation is legally sufficient if it describes the nature of the offense and refers to the statute or ordinance that gave rise to the citation. Additionally, although in Appellant's brief, he raised that under Criminal Rule 3, that the complaint must contain the essential facts, and it has to have the numerical designation of that full statute or ordinance. But as we see in the 8th District case, the Criminal Rule 3 does not apply in traffic citation cases. That would be Traffic Rule 3. And this is because the purpose of the traffic rules, in large part, are to ensure simplicity and uniformity in procedure. And the traffic code procedure is not controlled by the stricter, more elaborate rules of the more serious offenses.
Well, that aside, once a bill of particulars was filed, it seems like it wouldn't have been too difficult for the state to have indicated in response to it that, we're really focusing in on Section A, right?
And that would be the state, I can't speak for that prosecutor, but seeing that the failure to control corresponded with Section A, I believe they didn't see that there was a defect, if you want to say that it's a defect in the citation. So they responded to the bill of particulars and referenced and referred them to the citation. If there had still been any confusion about the charge, they could have taken it back to the prosecutor. Even the Supreme Court in the O'Connor case kind of said, defense counsel, if you're still confused, you can approach the prosecutor informally and say, we're still not clear what section. And that could have happened here. But I think given the title of the statute and the way that ordinance, the title of the ordinance and the way it's structured, I think it puts them on notice. The other issue that's been presented is appellants contended that the trial court erred, as I had mentioned, when it denied his criminal rule 29 motions about the close of the state, the close of all evidence. As this court's aware, it challenges the sufficiency of the evidence required the court to examine the close of the state's case and determine if the state's met its burden of production. So after viewing the evidence in light most favorable to the state, you have to see what the rational trier of fact could they have found the essential elements of the crime proven beyond a reasonable doubt. Here, because we have focused on failure to control the 331.34A, the state called 3 witnesses, and those were, as the appellant has indicated, Mr. Miller, who was the driver of the vehicle, Ms. Beachy, Mr. Miller's wife, and passenger in the vehicle, and Officer Laskowski, who was trained in traffic crash investigations. And at trial, Mr. Miller testified that he was sitting in his vehicle at the stop sign on Oak Hill Road, and he was waiting for an approaching vehicle when all of a sudden it swerved and hit him on the front driver's side of the vehicle. And then Mr. Miller also testified that he spoke with Mr. Warren, and that Mr. Warren had indicated at that time that he didn't know what had happened. Additionally, Mr. Miller's wife, Ms. Beachy, testified that she was actually looking down on the phone, but she heard screeching tires and looked up to find headlights directly in her face. The fact that you hear screeching tires, to me, indicates that the brakes are engaged and you fail to control, because the result was that they heard a crunching sound from the driver's side of the vehicle that was hit. Additionally, Officer Laskowski, who again was trained in traffic investigation, testified that he received a call to for an accident or no injury. After speaking with all the parties involved, he determined that Mr. Warren had been traveling west on West Liberty Street when he attempted to make the right-hand turn onto Oak Hill, and that's when he struck the vehicle.
Did Mr. Miller confirm that Mr. Warren had his turn signal on? Or was he silent?
I do not recall anything about the turn signal. I believe that he testified his exact words that it appeared that Mr. Warren, that was the officer. He actually didn't observe and didn't know if the turn signal was on, but Mr. Miller had testified that he was waiting on the truck and he indicates to go by. So perhaps
That's why I raised
yes.
that. It seemed, I read that in the brief and wondered if he was waiting for the truck to go by, whether that is consistent with Mr. Warren's testimony.
Your Honor, I hadn't thought of that or made that connection, but it would be consistent with Mr. Miller's testimony that he was waiting for it to go by when all of a sudden it swerved and just hit him. So I don't know about the turn signal for sure. So basically given the above testimony and the exhibits that were entered in at the trial court, a reasonable trier of fact could have properly found that the state did prove beyond a reasonable doubt that Mr. Warren failed to maintain reasonable control over his vehicle, which would then be a violation of 331.34A. In regard to the appellant's argument regarding the manifest weight, when a party challenges the manifest weight of the evidence, of course, the court gets to review the entire record and weigh the evidence. And all reasonable evidences considered most importantly the credibility of the witnesses. In this case, again, Mr. Miller, Ms. Beachy, and Officer Laskowski were all called by the state and they all testified. Mr. Miller not only, as we set forth, he testified that there was a truck going by and it was somewhere here and swerved in, and that was the transcript at 6. And then he does go on to say that Mr. Miller testified that Mr. Warren had been trying to negotiate the turn when his vehicle was struck. And so because the vehicle was struck, it's consistent with the trial court's finding that Mr. Warren did fail to control his vehicle. Additionally, Ms. Beachy's testimony regarding the screeching tires prior to the collision and the fact that the collision occurred, and Officer Laskowski's overall investigation, which indicated he believed that the defendant had failed to negotiate the turn properly, failed to control his vehicle. That all goes towards the trial court's finding that beyond reasonable doubt that a violation of the 331.33 did occur. I'm aware that Mr. Warren is contending that it's the state's burden to show the violation of 331.34 under A, B, or C in this section. Again, I think we've shown under A, the elements that the state was required to prove were that the defendant was operating the vehicle, and also that while operating that vehicle, they failed to exercise reasonable and ordinary control over the vehicle. All of the above-mentioned testimony supports that the defendant failed to exercise that reasonable control. Mr. Warren does seem to indicate that it was the state's additional burden to show that in a similar circumstances where there had been loose gravel on the road, where it had been raining, and where the defendant's brakes weren't working, that accident wouldn't have occurred. But that was the defense set forth by the defendant. As you indicated, it's not clear. Perhaps it had rained earlier in the day. That was the testimony, so we can assume that it had rained. Perhaps there was gravel. And with regard to defendant's allegations that his brakes had failed at that moment, there was testimony by Officer Laskowski that he actually asked the defendant to move his vehicle at one point, And so Officer Kelsey visualized the vehicle in motion and stopped without any problem. I believe Mr. Miller, actually, he also said that the defendant was able to move the vehicle from where the impact occurred out of the way so the traffic could come through, and again, the brakes hadn't been an issue. Additionally, the trial court inquired on its own if he had any prior concerns with the brakes leading up to this point, and there had been no concerns. So all of that was a defense put on by the defendant, and the trial court gets to determine the credibility of the witnesses and decide whose version of the events they found more credible. And in this case, the trial court could reasonably find and determine that the state's version of events were more credible. So that would lead us to there's actually, the trial court did not commit error, and it was proper to find Mr. Warren guilty of the violation of Mr. Codified Ordinance 331.34A. If there are no further questions, just in conclusion, I would just like to reiterate that as set forth in the Barberton versus O'Connor uniform traffic citation, the act really charges the defendant with an offense when it describes the nature of the offense and makes reference to the ordinance that gives rise to the offense. And as Mr. Warren's citation described both the nature of the offense and that made reference to 331.34, the citation was proper. Additionally, the trial court did not commit error when it denied the criminal rule 29 motions for acquittal as the elements of the offense failure to control under 331.34A were proven beyond a reasonable doubt. And lastly, of course, the trial court's judgment or conviction was not against the manifest weight of evidence, as the record clearly established beyond a reasonable doubt the defendant failed to control his vehicle in violation of 331.34A. Thank you.
I have two responses. Number one, the state did not have a theory for the case. The state merely said that there was an accident, therefore my client was guilty. That is not the law at all. I invite the court to look at the record because that will establish exactly what the facts are from all the witnesses' standpoint. None of those, the evidence, when you look at the record, it will not show there was any evidence of speed, any evidence of reckless driving, any evidence that conflicting with Mr. Warren's statement that he had his turn signal on. All we have are two people who said there was an accident, they saw the vehicle coming, and they could not say that it was going too fast, they could not say that there was any violation of failure to exercise reasonable control under all the circumstances.
What are we to do with the testimony of the officer after the accident, having observed your client moving his vehicle and braking with no apparent difficulty?
Well, he did say that. He said that my client moved his vehicle, and when I cross-examined him about it, I think he said he moved it like 5 feet. And this is a standard transmission, that is to say, so there's all sorts of ways that you can stop a vehicle without necessarily using your brakes, particularly if you're going up a hill, if you go up a little bit. There's a lot of ways that you can deal with this, but even if the brakes work to some extent at that point, Mr. Warren testified that there was a problem with his brakes, that he was unaware of it, and that he got it fixed after the accident happened.
Was that admissible or admitted in court?
Well, he testified that he didn't, but the actual receipt itself, Mr. Warren did not give me until the date of the trial, and the court excluded that, and it's not an issue here on appeal. But there's no question he testified that that's in fact what happened.
But to that issue of the standard transmission, it also allows you to downshift coming down a hill around a curve without using the brake, which would slow down the vehicle that way as well.
Well, he was actually coming up West Liberty, Your Honor. So he was He was coming up West Liberty, which is an elevated road, and then he was turning right onto this oak hill, and his trajectory went straight up the hill. So I don't think that he could, there was no evidence as to what gear he was in or what he did, but if there was going to be any evidence at all, if the theory of the case was he was going too fast coming around the corner, he wasn't paying attention or whatever it was, one would have thought the witnesses would have testified to that. These are now conclusions to try to support what the trial court's conclusion was, but the fact is that it's got to be based on evidence, not based on just surmise of what may have occurred, particularly given the fact that Mr. Warren testified uncontrovertedly as to what exactly happened. I just want to mention one more point there.
Unfortunately, however, Council.
Am I done? Okay.
We lasted 5 minutes this morning. Thank you both for your presentations this morning. From the making matter of advisement and your written decision, which we have both sides, as well as posted on the House Report website. Thank you.
Thank you.